Today, we step into a courtroom where accountability, second chances, and the harsh consequences of relapse are all on trial. The case of State versus Alicia Rubio isn't a dramatic criminal showdown, it's something more raw and real. Miss Rubio is facing the fallout of violating her probation conditions, and the stakes are incredibly high. We've got a judge who's striking a balance between compassion and control, a defense attorney stepping in to represent a client who's already walking a thin line, and a probation department that's not playing around. But here's where it gets interesting. Despite a past violation, Miss Rubio's drug test comes back clean. That alone shifts the tone of this hearing in a surprising way. The court's about to order mental health evaluations, a felony drug court referral, and more. Is this a just system providing rehabilitation, or setting her up with hoops too high? Too clear. Stick around, because in this quiet courtroom moment, there's a lot more at stake than just a motion to revoke. What do you think? Should courts give more chances like this, or draw a harder line on probation violations?
Ms. Rubio, if you'll come forward, please. All right, we're going to go on the record in 2022, CR 3602, State versus Alicia Rubio. Can I have parties announced for the record for the state?
Alexandria Vargas for the state.
For the defense?
Brent Lopez for Ms. Rubio.
And are you Ms. Rubio?
Yes, ma'am.
All right, so the previous attorney here was Anthony Cantrell, but my understanding, Mr. Lopez, that you represent Ms. Rubio as well?
Yes, Your Honor.
All right, so she entered a plea to violation of condition number 4. The court found that true. The court ordered her to take a UA. She completed the UA, and probation, what were the results?
Negative.
All right, and the results were negative. So probation and state, what were your recommendations?
We had recommended that she take a mental health evaluation and an evaluation to enter felony drug court as well as DDRF.
All right, and I think probation, you wanted an updated TAP evaluation? All right, so based upon your negative UA, the court is going to deny the motion, and you're going to have to make sure that you make all of these appointments. Otherwise, a motion to revoke is going to be filed. Do you understand?
Let's pause here and break this down. The judge just denied the motion to revoke probation based on a negative UA, meaning no drugs were detected. That's a huge win for Rubio, but it comes with serious strings attached. The court orders multiple follow-ups, a TAP evaluation for substance use, a mental health evaluation, and a referral to felony drug court, all to be completed while out of custody. This is where the real challenge begins. Staying out of jail isn't just about passing one test, it's about committing to ongoing treatment, check-ins, and lifestyle changes. And notice the judge's tone here. Supportive, yes, but firm. Miss one appointment, and it's back to jail. What do you think? Is this structure fair accountability, or an overloaded system setting her up to fail?
All right, so I'll deny the motion. We can do the TAP evaluation out of custody. And we'll do the MIC evaluation out of custody. And we'll do a referral to felony drug court out of custody. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court?
No, ma'am.
All right, we can go off the record. I'm glad you were able to see your sister. All right, so just make sure that you make all of these appointments, you understand? And don't fall off the wagon. If there's something you need or some other issues, let probation know. If you feel as though they're not addressing it, you can always come here. And if you think you're going to use, don't use. Pick up the phone, call probation, call your attorney, go do sober support meetings. You understand?
Yes, ma'am.
All right, thank you. You're welcome. Thank you.
Thank you, Judge. Yes, Your Honor. Thank you.
All right, thank you.
From a probation plea to a felony conviction, we now shift gears into a more serious courtroom setting. The next case, State versus Jeffrey Michael Olson, takes us into the world of plea deals, possession charges, and the very real consequences of controlled substance laws. Buckle up. This one moves fast but hits hard.
All right, are you all both ready? All right, court is calling 2024 CR 1882, State versus Jeffrey Michael Olson. Can I have parties announced for the record for the state? For the defense?
Jonathan Ross for the defense, Your Honor.
And are you Jeffrey Olson?
Yes, Your Honor.
All right, counsel, have you received all of the discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
No, Your Honor.
All right, Mr. Olson, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We will, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, waiving count one and proceeding on count two.
Any objection?
No objection.
All right, Mr. Olson, did you review the court admonishments and waivers with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count two, you're charged with possession of a controlled substance, penalty group one? Penalty group two, 1 gram to 4 grams.
Yes, Your Honor.
That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor. I believe him to be competent.
All right, and do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mr. Olson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count two. They're asking that your punishment be assessed at 2 years in the prison. They're taking in consideration 2024 PF 18919. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense as charged in count two, how do you plead?
Guilty.
State any evidence?
Contained in exhibit one and attachments, Your Honor.
No objection, Your Honor.
All right, state you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits one and attachments, and the court will review the same. All right, after reviewing states exhibits one and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We would, Your
Anything you wish to say on behalf of your client?
Honor. We just ask the court respectfully to follow the plea agreement.
All right, the court is finding you guilty. The court will sentence you to 2 years in the prison. Give you credit for any time served. Take in consideration 2024 PF 18919. My understanding that corresponds with 2024 CC 739546. Counsel, I'm sorry, you will have to take that.
Yes, ma'am.
There's to be no contact with Robert Charles Rigdon, Rigdon. And Serenity, Serenitty, Marie, Marie, Matts, Mateus, Mattes. And Todd, Todd, William Carrick, Karrick. And I order the therapeutic community. The therapeutic community does not increase the time you're in custody, but it's designed to help you if you have a drug problem or help you so that you will be successful and not reoffend. Do you understand?
And there it is, 2 years in prison, a waived right to appeal, and a harsh but heartfelt warning from the judge. Let's talk about that sentencing moment. The court followed the plea bargain to the letter, but the emotional gravity came. In the judge's final words, she compares prison time to slowly draining a bank account, one sentence at a time, one mistake at a time, until there's nothing left. She's not just sentencing Olson, she's pleading with him to stop the cycle, whether it's housing, inpatient treatment, or help re-entering society. The judge literally offers to make a call herself to support him. That's rare. That's human. What's your take? Is this the kind of sentencing that helps break addiction cycles, or just another entry in a long list of convictions?
Your Honor.
All right, is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
40.
All right, so here's the thing. Taking time for cases, 2 years here, 2 years there, it doesn't seem like a lot, but it starts adding up. It's similar to when you're trying to save money, and my mom always reminds me of this. You think, oh, I have great savings, right? But then you start chipping away at it. Oh, $200 here, $100 there, and then you look up, your savings are gone. If you continue the way you're continuing, you're going to look up and half your life is going to be gone. It's either going to be sent at the jail or at the prison, or either somebody's going to be identifying your body because you've gotten a hold of some bad drugs. You understand?
Yes, Your Honor.
So when you're released from prison, if you can't find a place to go into inpatient treatment, or you can't find housing, and I'm still here, you can always come back here and I will pick up the phone and call somebody to help you. You understand?
Yes, Your Honor.
All right, good luck to you, okay?
Thank you.
You're
Thank you, Your
welcome.
Honor.
Two very different cases, two lives hanging in the balance. In the first, Miss Rubio narrowly avoids incarceration, but faces a long road of court-ordered treatment and personal accountability. In the second, Mr. Olson walks into court, pleads guilty, and walks out with a 2-year sentence, but also a lifeline, if he's willing to take it. These aren't just case numbers and court dates. These are stories of redemption, relapse, and the razor-thin line between freedom and a prison sentence. If you found these cases as revealing and intense as we did, don't just scroll past. Let us know your thoughts in the comments. Should Miss Rubio have been given another chance? Was 2 years the right sentence for Olson? And hey, if you love deep dive courtroom breakdowns like this, make sure to like, share, and subscribe for more real-life legal drama that goes beyond the headlines. Until next time, stay sharp, stay curious, and stay out of trouble.